So picture this. You're a small employer in a small, tight-knit community, and you find out that one of your employees was very recently and very publicly arrested, perhaps for something that's particularly offensive. You're worried about whether you can deal with the damage to your reputation and wondering if you can let them go. So can you fire them is the question we get all the time. And I expect that every single business owner watching this is hoping I'm going to say, yes, of course you can. But the reality is that the answer is what it typically is in the world of employment law. It depends. This is a question we talked about in episode 90 of Fire Away, but it comes up a lot, and I want to repeat this and revisit the issue. So I know that it depends is not the answer most people want, but as anyone who knows me is aware, I've spent far too much of my career, far too much of my life studying the topic of just cause for dismissal. In other words, when can someone be fired from their job? And I've even written a book on it. The book's called You're Fired. And one of the things I have learned is that there are no hard and fast rules. But it's clear that the courts will always take a contextual approach, meaning they will look at all relevant factors: the nature of the person's job, how long they've been employed, have they been in trouble before, and how they respond when they are confronted, which leads to the second question we always get. Do you really have to give them a chance to explain? Here's a simple answer. Yes, you absolutely do. If you're even considering dismissal for cause, you need to confirm your suspicions and give the employee an opportunity to respond to them. And their reaction is often a critical factor in assessing whether you have just cause. Because remember, the test is whether the employment relationship has been irreparably harmed. I get a lot of pushback on this, and the most common response I get is something along the lines of, surely, if we catch someone stealing from us, we can fire them for cause. And the answer again is, it depends. Yes, if we're talking about your CFO, who has been clearly embezzling millions of dollars over years, you've got a very strong case for cause. But if you're talking about your receptionist, who took a pencil home at the end of the day so that their daughter could do their homework that night, technically that's theft. But I wish you good luck if you want to fire them based on that alone. So just cause is one of the most complicated areas of employment law. Courts take it very seriously because the consequences are so severe. They often refer to it as the capital punishment of employment law. So here's another intersection between employment law and criminal law. There's never, or almost never, an easy answer, but there's a very clear takeaway from this. Get legal advice before you act, because it almost always costs less to prevent the problem than it does to fix it. As we always say, if you think you might need an employment lawyer, you probably do.